and José Saint-Ange. Case 305 Barry Bastien. Case 243 Astrid Girip.
Thank you. Can you please call the witness?
Mr. Philippe Boulet.
Thank you very much, Mr. Boulet. Thank you for being available to come back again to continue where we left off this morning. We're very grateful to you. So we're going to we can't wait to hear. So we're handing over to you. Thank you.
Voilà, bon après-midi, Madame Chair, bon après-midi, Commissioners. Ma continuer côté motivité pour matin. Et moi pour get très brièvement, à cause du temps là, quitte nous. Moi pour get ça dès les autres gisements, de façon plus brève possible. Dès la Cour d'appel, par nous connaît nos trois gises, et ça dès les autres gises, c'était Justice Law and Justice Goburden. Ma 5 copies me passent avec commissionnaire Famé, gisement Justice Law. OK, on prend ça comme un second gisement. Gisement, un petit parenthèse pour commencer. Première ligne, première page. I have had the advantage of reading the draft, the judgment prepared by Mustafa J, in which the facts and the background of this appeal are so fully set out as not to require. So Justice Law is influenced by the word taking advantage of it was regrettable, because I doubt whether there was much advantage. But I will refer only to one paragraph, just to make the point. I will invite the Commission to look at page 4. Pages are on top. And if I may just read the second paragraph to make the point. Page 4, second paragraph, basically the bottom paragraph. With respect, there were plenty of suspicious circumstances attending the fire. But can the reasonable possibility of a malicious act of a third party or of accident be excluded? There we come, Lordship, again, malicious act of a third party. Why this advantage? All we need is a third party. A third party who sets a fire, as I said, and who is then proved to have done it on behalf of the insured. At this stage, malicious or goodwill is totally irrelevant. We throw that in as a red herring. So can it be excluded? Can accident be excluded? I think it can. The bakery was enclosed, and this is so important. I will invite the court to visualize what he visualizes. The bakery was enclosed by a high wall, whose gates were locked shortly before the fire began. So that if the fire was deliberate, it can only have been caused by some person who was on the premises. So I go back to presumption. If we presume the fire was deliberate, We will also presume that it was caused by the person inside the premises. Again, a double presumption. Presumption is you're allowed one on uncontested fact. So that shortly before, it can have been done, caused by some person who was on the premises. Now, a third presumption, excuse me. Presumably an employee. We haven't even seen by, who knows. So it's a person inside, presumably deliberate, presumably caused the fire, and presumably an employer. A treble presumption. Accident is also excluded. There was evidence that the electrical system was regularly maintained and in good order, and even if the diesel oil supply pipe had been accidentally severed, the flow of oil would only have been about half a gallon a minute. As already noted, diesel oil does not ignite except at very high temperatures. So what is the relevance of that is to say, Justice Law is trying to tell us somebody did not do it from outside, because cutting the pipe would not assist him. That's the only thing I can read into that statement for the statement to have any relevance whatsoever, because he wants the man to be inside. Or, as already noted, is also, unless there was an accelerant, this slow flow of diesel oil could only have formed a puddle lying harmlessly on the ground. Why the Honorable Justice wants a man to be inside is a mystery. So outside, no. He could never have cut it with the intention. It could not have ignited and diesel fiercely within a few minutes unless vaporized by great heat from another source. I am accordingly driven to the conclusion that the fire cannot be by accident. So he eliminates accident. And then the most beautiful conclusion, and that this appeal must accordingly be allowed. So all you had to do was to eliminate accident, and you've already, by eliminated accident, you've already established that it was done by a person, that this person ignited from within, and that this person was an employer. I will push this thing as far to show how really way out it is. Was there even an evidence that it was an employee, would advance the case nowhere. An employee could be malicious. Are you going to presume that the employee was acting? So he does three presumptions to jump to a final presumption, which itself is useless. I mean, this process of adjudication is something amazing. But of course, the flaw, which is quite amazing, which is not apparent, but which when I analyzed it was quite something. Was the man grilled inside? There was a huge fence. The gate was locked. So according to the judge, nobody could come in. So how on earth did the man get out?
A man or men.
How would they get out?
Yeah.
The police came, had to break the gate with an axe. Well, the reasoning is so you know, with the greatest of respect, so frivolous. It is senseless in terms of a reasoning. And I can say, no, there was no corpse inside which was grilled either. Neither did anybody see from outside. So, as bad as our good friend Justice Mustafa. Now, again, it's because of time that I am showing only the minimum. Now I will invite the court to look. I will invite the commission. Thank you. And of course, also the language. I miss it both there. Mon présent, mon point vite commission pour get sa caisse, sa dernière caisse qu'on va donner. 1, 2, 3, 4, 5. Dernière caisse, c'est pour jugement Gobert. Moi, tu dis, pour répéter ça que moi tu dis avant, ça dit comme quoi personne n'est pas capable, si on a un grand fence autour sa bakery, get une fois main, et l'une met un dimon en dedans, qui est présumé employé pour mettre du feu, sans penser qu'il n'a pas fait essence, qu'il s'assomme en dedans, parce que vous n'avez pas sorti, si il n'y a pas rentrer. Il n'y a pas les corps qui ne gagnent pas. C'est ça qui monte à payer. Présent, nous pour guetter un coup, Gobert. Je ne parle pas vite, je ne suis pas pour capable de montrer toutes les choses, mais ici, ma demande de commission pour guetter page 4, second paragraphe. L'annual. Sazis Goberden, Sazistis Goberden, lui dit comme ça. Mr. Wilmot was the major shareholder of CBIC Company. He owned 60% of the share. His wife was assistant manager of the company, and his son-in-law was the manager of the bakery. They lived close to the bakery. Where is that? Where do we get they live closer? They live at La Misère. Oh, well, now you feel they're distorting evidence just for the sake of arriving at a common conclusion. Close to the bakery. They were entertaining guests when they were informed of the fire at the Barnard. His lordship, the judge, he has got a very short testimony of Mr. Wilmot. Why not say the truth, what is in there? Why distort it? I am sorry to use this expression, but distorting is vicious. What is in the evidence? They were entertaining guests when they were informed of a fire in the vicinity of Shell Plastic, in the area of Shell Plastic and CBIC. Why not say that? Of course, they don't say that, because this is what they want to say the next thing. One would have expected Mr. Wilmot to rush to the scene of the fire to find out what happened. The fire, what? Yes, the fire in the vicinity. So he did nothing of the sort. In his statement to the police, which have been produced in the case by consent of the parties, he said that he did not go to the scene because he was entertaining guests. But he did not go to the scene because he thought it was there. Nobody had told him it's CBIC, and he sent his wife, he sent his son-in-law. Because he could not go, there were children sleeping. And the father went together with them. I mean, the statement is a short statement. Can you put that in there? Is there a use to distort it? Ultimately, he went to the bakery at about 10 when the bakery had burned down. What a devious turn of it. He went to the bakery when he was informed that the bakery was on fire. Or in one paragraph, a small statement which I gave to your lordship, short, easily have put it verbatim there, and every sentence is distorting that statement. He went when it was burned down. He went when he was informed by his wife that the fire was in the bakery. Ultimately, he went burned down. There is also evidence to the effect that Mr. Wilmot and family intended to leave Seychelles for good. There, just en parenthèse, I will say, Mr. Wilmot and hundreds of other people. In spite of the grave allegation of fraud made against his company, Mr. Wilmot did not intend it necessary to go and depone at the trial. Yes, we must, that I put it in context so much. Mr. Wilmot had been told by the insurance, let us wait for the police report. And rightly so, as I said, I don't criticize that, it's normal. The police report came out and laid absolutely no blame on Mr. Wilmot. What was he going to say? The burden of proof was on them to prove fraud. There wasn't an iota of proof of fraud, except by a machination. The atmosphere in Seychelles is well known, I explained it. He felt there were reasons to burn his bakery. He was scared he was going to be framed. So there we are. I'm saying that because a whole paragraph on which he analyzes the evidence is a total distortion. Then we come, as I say, we don't have time, so I will rush if I may. We go to the last page, which is page 5. On the facts before us, I am of a view that the learned trial judge has failed to appreciate the evidence. Again, some respect for the judge, please. You must tell him. A court of appeal is owed a respect to the lower court. You must tell that judge what evidence did he fail to appreciate, and which evidence are you appreciating different from his. Evidence, the company was, evidence properly. On the evidence, what evidence? What evidence? There's no evidence you've given us. You've given quadruple presumptions. I find that the company has made out its plea. I suppose the plea is fraud by getting somebody to do it, on a preponderance of probabilities that the fire was deliberately set to the bakery. Again, we find this beautiful phrase. By who? By say bake. So we haven't found somebody. That was the presumption. And there, which was a false presumption and which is not admissible in evidence. And eventually, because we don't have that, we have an employee, we have this, same thing. It was done by the company. Our company puts a fire. I wish the judge would explain us. So again, we see the same pattern. We see the same pattern of judgment.
To me, for whom this is all completely new and all the rest of it, it looks like the decision. Il paraît qu'ils ont fini prendre une décision pour dire pour pouvoir qui c'est bec qui en entend aux autres qui ne dit fait. Par exemple, tout ça bon l'argument il a arrangé pour fitter sa décision.
Pour sa décision.
Oui.
C'est exactement my feeling on it.
C'est vraiment clair.
Nous trois, nous pouvions un peu même quelque chose. Nous pas apprécier l'évidence, nous pensons pas mal, même qualité méli-mélo, Nous
Oui.
avons besoin de dire ça.
Oui, oui.
Alors, nous rodons ces mains.
Oui.
Nous ne sommes pas capables de prendre exactement même ces mains.
Yeah.
Ce monde a fait sa présomption, l'autre a fait sa présomption. Moi, je suis capable de dire autant quelque chose aussi.
And can I just ask the motivation on the part of the court? Would that be from pressure from the executive to make sure these people really?
I will explain that. It was thick in the air that we were going to lose that case. Very thick. I remember the court coming back.
En créole.
Je me rappelle, la cour a entendu faire session, pareil comme là. Ils sont venus sortir dehors, ils sont venus, il y allé, 3 mois, ils sont venus. Normalement, les autres retournaient, les autres rendent jugement. Je me rappelle dans ce cas, ils retournaient, et vous savez, pas jugement, tu n'as pas jugement. Je me dis, c'est drôle. Les jugements sont venus beaucoup plus tard, et Patigan ne donnait pas la cour d'appel. Si vous envoyé que c'est Citan, pour Citan lire. Pas qu'on est si je peux cramer pour lire ça. But it was not unlawful for them. Il n'est pas illégal pour eux faire. Nous avons le droit d'envoyer contre un juge. À cause d'un juge, il deemed to be an ad hoc judge of the Court of Appeal. Mais voilà ça qui est arrivé. Est-ce qu'il présent en euro, présent alors effectivement sa criminal case et faire une transition intéressante, sorti comme ça criminal case pour venir sorti le sa cas civil pour venir le sa cas criminel. Bon, ça side que c'est c'était. C'est très, un grand valet à l'époque. C'est dans ce secte du monde qui est dans plot là. C'est dans la ville. Secte dans Cebu, Shell Plastic, C-Steel, British Motors avec CB. It was prime side. C'est là qu'il trouve. Et ça, qui est important, ça side tient component important dans sa caisse. À cause l'assurance qui les nous taper vers la cour d'appel, ça coste fini prend tout business. Et un grand point de défense, ça coste. On appelle GIC pour le moment. Un grand point de défense, c'est que nous pas les payer, nous les reinstate. Et voilà ça dans tous les 3 gisements qui m'ont pas mentionné.
No, sorry, I'm not getting any of this.
Okay. What I
I've
was
just-
saying is that
yeah.
this area where there were 5 major industries was very valuable. And the burn size of Sebek was a very, very material item in the appeal, because one of the major demands of the insurance company, which they were pleading, is the right to reinstate. C'est ça dans l'azisme. Donc, c'est dit, nous pas les payer. We don't want to pay, we want to reinstate and ask for an order from the judge. If it was found from them, and this also was refused by the Supreme Court, addressed specifically. La Cour dit non, ça vient comme un dernier moment, il va faire sens. Nous attendons tout ça l'en est pour faire ça. Mais qui nous voit? Est-ce que le gouvernement ici, ils ont appelé gagner sa caisse? Si ils ont pas ici, qu'ils ont pas appelé gagner sa caisse, ils ont si pour jamais fait ça la terre. Mais pourtant, qu'ils ont fait? Jugement la Cour suprême, il est 17 octobre 83. Jugement la Cour d'appel le 4 septembre 1984. Et que le gouvernement il fait en mars 84, il compulsory acquires à la terre. Est-ce que le gouvernement est pour faire ça? Si tu as un essence qui perd, pour les gars, il dit par la couronne, ça la terre, l'assurance, pour lui, reinstate. Ça, pour moi, tiens, là, ça t'est arrivé, tiens, l'autre chose qui t'a fait causer que moi, vous dis-moi. Si vous avez fini pour la terre, un component important qui a vint siégé est l'ordre de la Cour pour reinstatement, qui cause beaucoup. Mais ça, c'est pas. Eh bien, si on les partage avec commission, voilà, là, moi, m'envoie un email contre mon client. Informe autres, l'OSA compulsory acquisition. Ça, il y en a beaucoup pour faire avec sa criminal case. Voilà, c'est à l'époque nous avons envoyé Telex. Et les autres avoir son date, il gagne typé à gauche. Mars 84. On dit avec M. Allen Wilmot, government acquired Sebek site under compulsory land acquisition. I am claiming compensation on behalf of Sebek. C'est à l'époque, on s'est contacté aussi avec la banque tenait mortgage. Alors, M. Wilmot s'est dit, bon, contacte avec la banque qui m'a hier. Autres les qui nous fait ça ensemble. Moi, tu claim compensation. Moi, c'est bizarre. Moi, tu commences à gagner ça grand doute. À cause ou pas capable de finir sa caisse. Présent bien si, et ça nous peut rentrer dans sa criminal case ici. Il faudrait qu'ils m'ont dit, avant qu'ils m'aillent plus loin là, à cause que ça a beaucoup valeur, ça site. C'est joli, comme s'il faudrait nous décrire ça site. Nous qui sommes là, nous connaissons. Tout ça, bon endroit, c'est un grand parking, immense parking de Bossébek. C'est une plantée devant un joli pied coco. Et du monde, bien sûr, tout le monde s'y laisse ça. Alors, nous, ça peut gagner faire. Moi, je gagne l'offre. Moi, tu gagnes l'offre, enfin, plusieurs du monde viennent voir. Moi, je me rappelle, moi, tu gagnes l'offre 100 000 euros, puis moi, tu dis, autres 100 000. Moi, tu dis que mon client n'a pas besoin d'accepter. Il faut donner notre plus haut. Et du monde, tu laisses ça. Naturellement. Et, so, moi, vois autres un l'autre, lettre. Et là, ça est. En septembre 1995, vous dites autres qui m'ont gagné l'offre sorti contre gouvernement. Non, pardon. Oui, voilà. Non, on donne ça. N. D, 3, 4, 5. Donne ça, s'il vous plaît, Madame Chérie, commissionnaire. The bottom one is the first one, which I will refer to. Is a letter of 15th March 1995. So it's in part tout ça l'état. Of the above company as Le Rocher. I have already informed Standard Bank of the offer, and as they will be the recipient of the compensation as mortgagee, I have asked them for their views on this matter. Please let me know whether you are prepared to accept the offer, and then I will deal with the government and the bank in the light of your reply. On nous get ça, l'aide présentement, l'aide gouvernement en l'air. Addressed to me, without prejudice, I have been directed to make you an offer of 31,000 as total compensation in respect of the above-mentioned acquisition. Next line is very telling. Value of the land has been found to be nil in accordance with the second schedule to the Lands Acquisition Act 1977. And the structures thereon have been valued at 31. These are the burnt structures. I would be therefore grateful if you would inform your acceptance of the offer. So this is what, of course, there was no room for argument. I wish to point out, now we are going to move to the criminal case. Criminal case said they arrived at no conclusion. I'm saying this criminal case should be reopened in the light of that. Number one, I believe the acquisition was an interference with the duties of the court, with the procedures in court. Sa acquisition est une interférence avec le système judiciaire, les autres appellent ça d'autres fonctions, à cause l'assurance demandée pour reinstate, comme impossibilité. Mais please, on nous get ça un peu plus loin. À cause du gouvernement n'a quoi ça la terre. Sa section les mamelles, si gagne mettait pour business privé. Première question. À cause zoti à quoi ça la terre? Justement pour poser question et nous avoir si nécessaire pour ouvrir sa caisse. Seule motivation qui m'ont capable ciserait, c'est qu'ils ont partilé qui sébec, ils vendent à la terre. À cause où on peut se vendre sur la terre. Qui manière où on peut se vendre sur la terre? Ou à quoi sur la terre? Et très convenient, ou à quoi? Ou dit sur la terre, pas venir rien du tout, on va la loi. Ça, c'était un grand malice. C'est malice qui commence à faire avec monsieur et madame Wilmot. N'a pas l'explication. Vous voudrez dire monde dans le gouvernement, il vient, il demande l'explication. Qui ou peut à la croix, un bout de la terre là-bas. Et, vous dites, non, rien du tout, vous donnez quel autre dimanche. Alors, c'est un pire malice. Présent en nous al plus loin. Si autres partis qui, M. Wilmot et son famille, ils gagnent un petit l'argent pour vendre sa brûlée, qui plie la force par les autres, qui ban Wilmot, ils vendent sa bakery avant qu'il brûle. Si les autres partis, même ou les qui vendent un bakery brûlé, par malice, qui plus fort cette malice, c'était pour que les autres vendent un bakery, les y encore pémassé. Voilà question déterminante pour sa criminal case. Si vous partez ou les, est-ce que vous avez ou les qui autres vendent ça? Des millions les pémassé? Et l'autre question motif. Si vous utilisez ça l'endroit, à cause ou parti à quoi les outils connaît, Mr. Wilmot, il les vend est encore pémassé. À cause. Eh bien, si, clair, à cause. À cause, si ou t'a quoi l'île est pémassé, tu vous besoin d'un bon Wilmot là, ça? Ou c'est pour faire d'autres malices. Mon papa montre les doigts, mon papa montre des bonnes questions. Qui m'a rien dit monde qui t'y laisse à l'endroit pour faire malice, pour payer non rien du tout, ben Wilmot qui ont le poste vide. Qui meilleure façon pour punir ben Wilmot pour faire le poste vide? Ou brûle ses becs? Ou dire, il reste ici la terre. La terre va donner 31 000 roupies. Et ou à quoi? Si vous utilisez à l'endroit, à cause ou pendant quoi les becs sont encore pémassés. Sa seconde acquisition, c'était pour faire malice. Pour lui, pas gagner 100 000 roupies. Si un dimanche capable explique-moi ça. Là, nous avons tout un motif. Ce n'est pas un motif pour moi, montre les doigts. Pour montrer que ça caisse mérite réouvert. Nous avons l'évidence un motif malice. Là. Elle a bipouvoir presque criminel. Pour prendre un petit bout de la terre pour payer Saint-Dimon, gagner un petit peu l'argent. L'eau casse la terre. Est-ce que tu n'as pas une motivation pour payer gagner plus l'argent? Pas vendre ses becs? Ou bien si vous utilisez la terre? Ou prend la terre? Pour moi, il est clair. Un dimanche, on a un bi, c'est détruit Ban Wilmot. Et nous, on a l'évidence. On a l'évidence, sa l'intention au moins, dans sa lettre. Et nous, capables, expeignent nous l'esprit, vous dire que sa l'intention est toujours là. Sa l'intention, pas de descendre, un jour, descendre nous la tête un dimanche. Sa l'intention, est besoin, là. C'est bec brûlé, ne pas gagner rien. Est-ce que ça, tout ça là, pas une seule transaction? Et laisse-moi dire quelque chose aussi. Ça, à l'époque, pareil, nous connaît. Et moi aussi, il y en a beaucoup qui viennent devant sa commission. Là, la police, tu fais une enquête. Ça, à l'époque. Quand tu es quand même devant la commission, que ce soit l'enquête disparition, que ce soit l'enquête la mort, aussitôt que la police y découvert un dimanche, si ça dimanche, il y en a un statut, il y a un frère. On voit ça dans tout cas. C'est pourquoi aujourd'hui, nous connaissons lesquels ça bon dimanche. Qui m'a dit la police pas dit qu'on lesquels ça bon dimanche. Et tiens, un sous-entendu, pareil, nous dit, il est ou arrive là, si vous tapez Sami ou arrêtez. Et moi, je crois à la police qui connaît lesquels. Il met ça.
Je crois à la police qui connaît qui s'est dans
Yes.
le médifé là-bas.
Yes.
Ah, ok.
Dans sa petite île indiffée.
Mais en même temps,
Sorry,
Is it
can you
friends
speak a
affair?
little louder so I can hear you? I can't hear you. Yeah,
en même temps,
I can repeat, Madam
that would
Chair,
be good.
if you
Yes, please.
wish
Yeah,
anything.
thank you.
What I was saying is, I think you got the part where I was explaining that if the intention of malice is proved by that letter, to deny the Wilmots the final little bit of money they could get. Compulsory acquire. If they wanted that property, why did they not acquire it while it was running? Because that would not satisfy Malice, because they would have to pay for it. How does one ensure they get nothing? To burn the building. Interfere with the court. And then make sure that it costs you nothing to go for the Malice. You have the Land Acquisition Act. You have to pay nothing. You've left it bare land, and value of the land has been found to be nil in accordance with. Thus, the plot is to make clear. Even the sale they did not want. And this acquisition was done so with such malice that they even cut across court proceedings, of course, knowing that it would cost them nothing because the court was going to go their way. The last thing I was saying, Madam Chair, is this. As is well known, I've heard the Commission all the time complaining about the availability of police files. It was known at the time. You know, all these disappearances, the killings, the bombings, everyone knew who it was. And now the Commission, well, many of them knew. And if we knew who it was, surely the police knew who it was. But there was a code. The code was clear. You investigate, you investigate, you investigate. You hope you'll get somebody who is not up there. When you hit there, boom, file closed. To me, I believe that this case, the investigation found the wrong person. When I say the right person, but the untouchable. This is what I believe. The police, when they gave evidence in court, said the case is not completed.
It's not?
Completed.
Completed.
The file was not closed, and they were investigating arson. When did it close? In my very humble opinion, this case should be reopened. To find out, we are talking of a criminal case. We are talking of arson, life imprisonment. As serious as all the things that have come before this court. There are witnesses available. You know, there is a person who was interested in buying Sebek. He lost a very good deal to Mr. Kesley. Of course, it was a good deal, as we all know. Maybe he can give evidence. What did he find out? Who made the malice so that he also loses? It would be very interesting to hear Mr. Kesley Saint-Ange, who is in South. Now, if I was intending to buy a boat, a beautiful boat, and somebody sinks the boat, I would want to know, was it a malice to me or to the other one? Human nature, you know.
But at the same time, though, the Saint-Ange family were well connected to the party, so to speak. I mean, Mr. Saint-Ange was a minister then, wasn't he?
He was, I believe, yes.
I mean, the father of
Yes, he
Jose
was.
and the others.
He was.
that wouldn't have had in those days, in that context, wouldn't have had an influence?
Is to be found out. All these, I must say, Commissioner, very, very valid points.
Who became the owner of the land afterwards?
Afterwards, I think it went to PNLAC, I think.
Oh, PNLAC.
Yes,
Okay,
yes.
yeah.
Yeah, it went to PNLAC. So it went back into private ownership. Why it had to transit through the government, that was...
There's something that I wonder whether the judges, when they were giving their rulings, if they were aware of. They made a big thing out of the behavior and conduct of Mr. Wilmot. That Mr. Wilmot had written cancellation notices for his insurance policies. Were they aware that SACOS was taking over all the insurance business and therefore general insurance would basically cease to exist? So he would have to cancel those anyway.
Correct. It actually came out in the evidence. That was explained.
Then the question of his mentioning his intention to leave Seychelles. His land at Captain had been acquired.
Right. His home, where he lived.
His home. So that would have disgusted him enough, I think, to get out of the country.
Exactly. There's
So-
all these elements.
All that big business about his behavior and conduct doesn't hold any water at all.
And on top of it, I think they knew it did not hold water. This is why they distorted it. Every time they mention his statement, it was distorted. Just saying he intended to leave. How many people intended to leave? As Commissioner rightly says, he felt victimized. He had his house acquired where he was living. How much more frightened will you be of a government? And that house was on something like 60 acres of land. So not only was his house acquired, all his possession in terms of property in Seychelles. And he went up to La Misère to list property. So they made so much heavy water out of that, which all very puzzling. I would add maybe two things. On the civil case, I think humbly suggest this is a plain perversion of justice. This is a manifest travesty of justice. And there should be a consideration of compensation for what they have been through. It is a serious suggestion I make on their behalf. On the criminal case, like in all cases, maybe we all invite the person who put that fire to come before this court?
Commission.
Before this. Créole en plus. Lève-moi l'anglais, vous dérailler complètement.
Yeah.
Bon, on retourne à quelque chose, c'était quelque chose bien simple. On l'a dit que l'autre côté civil, c'est une grande injustice, une perversion de la justice. Et mon Dieu, assurerait tout humblement que ça, la famille, il mérite une compensation. Présent le côté sa caisse, c'est un crime. Hassan, c'est quelque chose qui fait 10 monde en prison pour la vie. Ensemble, quelquefois, nous sommes capables de demander ça 10 monde. Vin devant, Redeem sur les corps, si ça fait de l'eau. À cause de moi, mon capable de donner l'assurance. Ça dit.
Honesty.
Monsieur Wilmot, il est un bon dimon. Il est un dimon très honnête et un dimon avec un très bon équerre. On n'a pas aucun doute qu'il Salaz qui est arrivé, il peut envoyer sur la main pour chacun pour pardonner sa dimon. Ça qui nous rôdait tout sur la vie, c'est qu'on est lesquels sa dimon qui détruit son la vie. Mais avec son caractère qui m'ont décrit, sa dimon, mon capable de dire, Monsieur Wilmot, pour pardon. C'est un dimon qui en a sa caractère, qui en a sa l'équerre. Il peut avoir de vengeance, il peut avoir de closure de ses affaires qui détruisent son la vie. Et qui ne prend beaucoup de temps pour rebâtir son la vie. Alors, vite ça dit, si ça fait ado sur la tête, vient devant, et tout ça là, la gagne derrière nous. Et si pas fait, bien si la police, on croit, et sa commission, il est capable de poursuivre sa caisse clairement quand il y en a. Un motif, pas derrière, un motif, c'est ça qui nous rôdait pour nous ouvrir à l'enquête. Voilà comment j'espérais qu'ils m'ont, dans une petite façon, mon capable d'aider sa commission, sa caisse, avec sa dévolée. Et on remercie la commission pour sa l'opportunité et pour la patience. Écoute-moi. Et s'il n'y en a aucune question.
De mon côté personnel, il passe ça dans une question pour mettre la lumière là, mais aussi. Et une façon de comprendre le système judiciaire dans un certain contexte. Ban intervenant, ban acteur, système qui a été évolué, une tractation, on peut pas le dire.
Tout à fait, commissionnaire.
Une tractation parce que, à cause un juge, si par exemple, à en faveur de la justice, il peut entorser la justice.
Tout à fait.
Et il peut entorser la justice, il peut really faire du tort un du monde ou un ban du monde.
Et pays en entier.
Voilà.
Entièrement d'accord,
Et mon
monsieur le
conclusion de
commissionnaire.
ça, tout ça par le cas présenté à cause manière où documente les, manière où explique les, il y a même une certaine conclusion et interprétation qui est vraiment très importante.
Merci pour ça, qui m'ont arrivé. Il aborde ça de sa façon, qui on met dans la lumière là. Merci, commissionnaire.
There's a fellow.
Looking at this one, Inspector Payette, the chief fire officer, or some of the people that appeared as witnesses at the time. I mean, if the police know, I mean, they might tell us if the person responsible doesn't come forward to tell us, then maybe the people that were involved in the investigation. We have a police name here, but I'm not sure if this person,
Bédier,
He was a fireman.
this one,
Sergeant Musby.
is it Musby or it's no S there? Ah,
Musby.
Musby, not Ronnie Musby. No.
Musbe was with the fire brigade, was he?
Brigade.
Yes, then for
Yeah.
the CID investigator,
Who
if I
was that?
recall,
Yeah.
was Mr. Bédier. But he's no longer,
Paul Beddy.
that is
Yeah.
correct.
Yes, we have his contact.
Madam
We have
Chair.
his contact.
Yeah, he was the one who came to court, who said himself to be, I am a CID officer in charge of the investigation. And he's the one, I think, if I remember rightly, who said, investigation pas complétée.
Monsieur Payet, c'est Monsieur Payet qui avec bonne nouveau la religion born again, c'est pas quoi là.
Ah oui, c'est un monsieur Payet qui est là.
Tu fais,
Correct.
Pascal Payet.
Correct. He's now a pastor.
He's passed away?
No. He's a pastor.
Oh, he's a pastor.
Pastor.
Yes, it's the l'église Parole.
Yeah.
It's Pascal Payet.
Yeah.
But so there was no actual criminal case because they didn't take Sabek to court
There was no,
as one big criminal. No.
no criminal case whatsoever.
Sebek
Correct.
was not the first company that got its building burned. Earlier, Ali Parker had a coconut fiber factory at the junction of Les Mamelles Road and Montfleury Road. And one
Correct.
night it just caught fire.
Correct.
Correct.
And of course, there was all the attempts to set fire, which we know. The bomb at Adamusa was intended to blow the little petrol station that he had. When I say petrol station, he had this wonderful machine where he dipped a pipe into a barrel and then pumped it. It would go in one. As a kid, we loved to look at that. You know, my father would stop there. The petrol going in one tank, put it down, then it would go into the other.
La bonne fin was 10.
And of course, it was correct. It was so dangerous there because there was a benzene in a barrel open, plus there was barrels of, and a bomb had been put there.
Extra supplies.
Correct. So, yeah, it's not the only one. I'm grateful for the commissioner to remember the Parker case. It was a factory that had produced it was in fact an interesting factory that took over from Copra.
Yeah.
Because then instead of using the nut, we were actually putting value to the husk.
Yeah.
The roof of Sebek, was it in asbestos?
Quite interesting, yes.
There's a picture somewhere.
Yes, in fact, somebody described it in the evidence. I think it was the man of the fire brigade who described it. The roof was,
Because what,
as several roofs were at the time.
like that coconut fiber factory also had a roof of asbestos. And what, I was living nearby, what alerted me that there was something wrong was it sounded like popping, like gunfire or firecrackers.
I see. As it blew.
It's the effect of the heat on the asbestos, it just blows up,
Interesting.
pops, just like big firecrackers.
It's most probably the crack which was
They said they heard.
that they heard. That was interpreted to be a device used to light the fire by one judge. Yeah, it was amazing, the asbestos. There were some entire houses built of asbestos.
Incidentally,
houses.
the judge Goburan there, he quotes Payet wrongly. He says that Payet said diesel is an accelerant.
It was the
Correct.
opposite.
He didn't say.
It was the opposite.
Correct. He said
Yeah.
it needs extreme heat to vaporize and then cause assist in the fire.
I have to say, you really did justice to the complainants in this case with your presentation, pointing out all the, I don't know how to put it, the comedy value, which is a terrible thing to say. I know we have to be respectful, but of those appeal judgments, I mean, it defies belief in a way. But I'm still trying to understand how they thought that reasoning was going to be accepted.
Correct.
And obviously there was no
Sad.
way to challenge it, right?
So sad.
Yeah, so that is really quite... interesting, but also in terms of this idea that we have been looking at, and you've helped us a lot about executive influence upon the judiciary. One of the difficulties that we have, I think, in all of our work is that we are directed to identify the individuals responsible.
Right.
You know, whereas human rights violations are state responsibility, we are directed specifically towards individuals, and there's nothing said about institutions or authorities. However, an individual who acts on behalf of the state authority is an agent. So we go back at the end of the day to state responsibility.
Indeed.
It's only going to be the private, if it's a privately motivated malicious act without any connection to the state, that it will fall outside of the consideration we can
Correct.
give. But in some of the, just with the, I mean, because I'm a bit like you, raised to be very respectful of the judiciary and judicial decisions. And when we come to these cases where we see these judgments, it's very difficult then in Mr. Mustafa of his past to say Mr. Mustafa bears individual responsibility for this travesty of justice as an individual, but we also visit it on the state. I would be much more comfortable saying it's state responsibility because the executive should not have ventured into the judiciary, right? But it's sort of, that's one of the problems we have when we come to looking at these judgments.
Correct. Correct.
I mean, in this case, it's obvious to me, very, very obvious. In other cases, you have to always bear in mind that reasonable minds can differ, right? So it's a little more difficult to say the judge is individually responsible, whereas we might be comfortable saying the executive infiltrated more generally the judiciary, right?
Interesting concept.
Yeah, yeah. But you did mention something like that when you were here. You talked about the institution, the judicial institution, more than the individual judges in it, if I recall correctly.
Correct.
Yeah.
At the end of the day, this is one ramification. Well, finally, we can describe this, an abuse of immunity. Which unfortunately is not a recognized offense. But in the greater scheme of things, if we go to the Nuremberg trial, one of the most wonderful cases, and in fact there was a film made on there, was the trial of a judge. I don't know if commissioners have seen that. It is one of the most interesting trials at the Nuremberg, was the trial of a judge. And a film was made on there. I really recommend Madame Chair saw that film. In fact, the judge, one felt so sad at the end of the day, because he was a very honorable judge. And for that little mistake he made, in defense, he offered all his records and says, look at all my judgments. Can you find a fault? I've been straight, but he was tempted and fell in one major trial under the influence of the Nazi. And he was convicted. And it's a beautiful, beautiful film which shows how strictly the duty of it, how it's pegged for democracy, for the sake of democracy, how one pegs the judiciary to such a high standard. If it is not there, the whole democracy suffers. This is why it's a... And of course, there they did not hesitate. They did not go in this business of the judge's immunity. It was one of the cases where they said, no, you are responsible for the genocide indirectly. So, as I say, an abus de l'immunité.
I like the concept of abuse of immunity.
It's not known in our...
Very deep.
Yes. It's not known in our law. It's not known. Was only known for crime against humanity and the others. But it does exist.
I mean, I think at the end of the day, what that example points out is individuals, right? It's the actions of individuals. The state itself has no personality as such, no individual personality. And if judges had resisted these temptations, then you wouldn't have obviously unjust judgments. But the context of the time, it seems it was easier just to go along, right? For your own survival, necessary.
So sad.
If you don't like it.
I think we will follow up with Mr. Kersley St. Ange and Inspector Pascal Payette, who's now a pastor, Paul Bedier, and Superintendent Laru I saw. Is he still around? Laru? This one. Do you know?
He's in Australia, I think.
Yeah, but we can contact him. But I think we have a much better understanding of the situation now. Do you
Thank
have any
you,
more
Madam Chair.
questions? No, we have no more questions unless there's something you would like to add.
No, I'm grateful for the time given and for having listened to me. I've got nothing further to add except, as usual, to thank you very, very much for the opportunity and to wish again, they always take the opportunity to say bon courage and well done. Please carry on. Merci.
Thank
I
you.
always
We-
enjoy
yeah.
your presentations.
Yeah.
Merci, Commissioner.
No, but
learn
you
a
really
lot.
helped a lot. You know, this has made it much easier, this case. I wish we could call upon you for all of them, right? But
Merci.
Thank you for the documentation as well. That's also very helpful.
Pleasure, Commissioner.
saves Mr. Investigator over there. So thank you very much. So we will adjourn, and we
Thank you.
are coming back tomorrow at 9 a.m. Thank you.
All right.